Well, good afternoon. My name is James Vann. I'm one of the attorneys at Vann Attorneys, and we are really thankful that you have signed up for today's webinar. It's obviously a popular topic because we have a large number of folks who have signed up, and we're hoping that this will be beneficial to you. So, as many of you know, if you have a question today during the webinar, you can use the Go To Control panel on your screen and submit a question that way, or you can send it to an email address, which is webinar@vannattorneys.com, and we would be glad to answer your question. And I really would encourage you, because I promise you, if you've got a question, it will probably benefit some other folks as well. And while we're doing a little bit of homework, so mark your calendars for April 16th of this year. We're going to have our next webinar, and it's going to be on collecting business debt. So again, that's April 16th. You will get an email here. Won't be too much longer out to get you to sign up for that. So again, April 16th. We're going to be talking about liens today, and I'll tell you it's really interesting. We try to come up with topics, throughout the year that hopefully will be helpful to people. Um, my experience so far for 2026 is that liens have been a lot more liens filed, I would say, this part of the year already compared to last year. Some of it may have extended over from the end of last year, but we've seen quite a bit of activity on liens. So we're going to be talking about liens in North Carolina. And again, that's liens specifically that are in North Carolina. And hopefully this is helpful to you. So we're going to be looking at what notice is required. What's the time frame for discussions with your customers, right? With folks that you're contracting with. And then how do you preserve your lien rights? Is a lawsuit required? Stuff that's sort of the general thoughts we're going to be sharing today. I was going to talk about payment bond claims. I don't know that we're going to go into payment bond claims today, and I'll tell you why, because I wanted to make sure that we hit claims of lien sufficiently. I know some of y'all do work for like the government, right? So that's where you're really going to see the payment bond claim issues pop up. Schools, like the universities, maybe not as much hospitals, sometimes prisons, road work, possibly, right? Those where you see the payment bond claims typically. If you have a question about any of that, please let me know. I'll be glad to help you with that. But I didn't want to mislead you, but we were going to do that. But I know more of you probably do private work versus doing the public work. So I wanted to mention to you just to think about this, right? In North Carolina, there's really three types of liens, right? There's a claim of lien on real property. There's a claim of lien on funds, and then you can have a claim for both together, like claim of lien on property and on funds. So think about this, right? Someone has to have a contract with the owner to have a valid lien claim in North Carolina. So we've got an example of what's not uncommon sometimes, maybe on a commercial project where you have the owner, maybe, and then you have electrical contract, subcontractor, plumbing, HVAC, and so forth, right? The owner serving as their own GC. And in this kind of scenario, if you were on that first tier, right, where it says electrical sub, plumbing sub, HVAC, so forth, you are considered contracting directly with the owner, and you have a direct claim of lien on the property, which is a huge advantage because, see, there's nobody in between you and the owner, right? Your claim of lien on the real property really can't get harmed by anyone in between you because there is no one between you, no other entity between you. So if you were in that first tier line, right, and you were not paid, you would have a right to file a claim of lien on the real property that's owned by the owner. And again, you'd have a direct claim of lien on the real property. No one in between that could mess that up. Versus a subcontractor's claim of lien. So you've got the owner, you got a general contractor, and then the first tier and second tier. So again, think about this. If you are, say, in the first tier line, right, electrical sub, plumbing, HVAC, you're going to file a lien on the property, and you're going to have a claim of lien on funds. If you think about from the owner standpoint to the general, think about that sort of as a funnel, right? The money starts at the top, the big end of the funnel, and it comes down to the small end. That's where it comes through, right? You're trying to capture the money owed from the owner to the general, or the general to the first tier subs. If you're a second tier sub, maybe you're trying to capture the money in that chain. Or if you're a first tier, you're trying to capture the money in the chain between the general contractor and the owner. I hope that makes sense. Again, so a lot of times you're thinking about this, right? This is the claim of lien, direct claim of lien on real property. This would be a subcontractor's claim of lien, where you could have a claim of lien on the real property, but also on the funds. And I said earlier in the first slide here, where you have a claim of lien on real property, there's really no one in between you and the owner that could change things that could impact your lien. Now, the owner could file bankruptcy. That would impact you a little bit as to how you would enforce your lien, but there's really no one in between you that could mess that up. Versus if you are a first or second tier sub, and there's obviously someone in between you and the owner, there are times when that person in between you and the owner could reach an agreement, again, primarily before liens are filed or lawsuits are filed. And they could sign, say in this case, the general contractor could sign a full waiver of lien, right? Early in the project, not when you sign the contract, because that's unlawful. But let's just say the project's a 6-month project. 4 months in, the GC and the owner work out a deal with the balance of the payment, and the owner says, I want you to go ahead and sign a full lien waiver on this project, and the general contractor does it. That theoretically, if no one else has filed a lien yet, that would really take out the right for a first or second tier, third or third tier sub to have a claim of lien on the property or on the funds. I really think that's unconstitutional, but it's part of the law currently. I wish somebody would contest that, but unfortunately that hasn't happened yet. But again, this is a subcontractor's claim of lien. So what notice in North Carolina is required? Some states, right, have a pre-notice. North Carolina does not have that. North Carolina has what's referred to as giving a notice to the lien agent, and that creates a lien. This lien agent law creates a lien agent to give pre-notice to. This law came into effect April of 2013. It is an online system that's managed by a group of title insurance companies. It is not a public domain. It's not a public website. It's not maintained by public funds. A group of title insurance companies came together, pooled their money, and came up with this process. And you can see liensnc.com. Probably many of you have an account there. If you don't, I would encourage you to do that, because if you're on a project and you are supplying labor or materials, then you really should give notice to the lien agent. The purpose of this lien agent statute, going back to when the housing bubble popped in 2008, the title insurance companies went ballistic because they said they were losing money. And in reality, I don't think they lost money. They didn't make as much money as they had made years earlier. But I don't think they really lost money. But they were like, we don't know who's on the jobs. Well, that's easily handled, but that's unfortunately in the negotiating at the legislature, that didn't, they pulled a card out and said, well, we're just not going to write policies anymore, which we all knew was not correct. But the legislature said we have to have work on a deal, right? So they came up with this lien agent statute. I remember a client of ours who part of the group is on this call today, asked me one time after this passed, they're like, well, who does this benefit? Does this protect us? No, it does not. It protects the title insurance companies, but it puts your foot in the door. If you haven't filed a lien agent or notice to the lien agent, you're theoretically or actually legislatively prohibited from filing a lien. It's interesting, that doesn't come up much in litigation, but I will guarantee you the times when you don't file a lien or notice to the lien agent, it's going to create a problem, right? If you don't get paid. So my advice to you is figure out what the best process is for your company. Do you file a lien agent notice on each project? Or I know a lot of you have monetary criteria, right? For example, if I want to provide X number of dollars in labor and materials, or my contract is X number of dollars, then I'm going to use a notice to the lien agent. I want to make sure you understand something because people get this really confused. It is not a lien at all. When you file a notice to lien agent, it sends a email to or notice to the lien agent for the owner, and it also sends a notice to the general contractor. Um, some people get really upset once a sub uh, gives notice to a lien agent. That don't let that bother you because it's not a lien, right? And I've heard other people say, "Well, I've already filed my lien." Where'd you do that? On liens NC. That is not a lien. You can't do that. So that don't get lulled into sleep to thinking that that's what that you filed a lien just because you gave notice, because you haven't. So here's a few definitions in the statute. I'm not going to go through them in detail, but y'all can obviously, you'll have a copy of this if you haven't already downloaded it, that you can refer back to. But obviously, an owner, someone who has an interest in the real property. That could be an actual owner. It could be a tenant of leased property. They have an ownership, even though they don't own the property, but they have an ownership that's worthy of having a lien filed against it. A contractor is whoever contracts with the owner, first tier and third, second, so forth. So hopefully, I'm sure that makes sense to all of you, right? So the lien agent is a title insurance company or company's designed, designated by the owner to receive the notice, right? You don't have to mail it. You don't have to fax it or email it or anything. Once you give notice on the website, it then sends it to everybody else that's on that chain. An obligor is someone in a chain that owes an obligation to someone else. So again, that's just sort of some general definitions. So in North Carolina, they said for projects that are $30,000 or more, when the building permit is issued, then those are the jobs that are required to have a lien agent. So a lot of times when the contractor or the owner, whoever's going to do that, goes to get the permit, thankfully now almost all of the counties have realized and understand what they have to do. They have to have a lien agent prior to going and getting the building permit if it's $30,000 or more. There are a couple of exceptions. We won't go through a lot of them, but for example, if someone's building their own home, that's one of them. And I know some people call me up and go, "Hey, we can't find this lien agent, right? I don't know, on the website, I can't find it." And sometimes they just don't exist. Even though statutorily the job is over $30,000 and it doesn't fall within one of the exceptions, for some reason they just don't have it, right? I think I could probably count maybe 4 or 5 times I've heard clients talk about that. And if you can't find it, then that's okay, right? Don't worry about it. The good news is on this statute, unlike the notice of another statute, which we're going to be talking about in just a little bit, giving notice to the lien agent, if you can't find it, right, you can go to the job site and look on the bulletin board, and it's supposed to be there, and it's supposed to have a QR code, so you can take your phone, take a picture of it, right, and go to that link, and it'll actually take you to the Liens NC website where that notice to lien agent is filed. So that's one way of finding. And they're supposed to put this on the job board by statute, which is great. So hopefully that helps, right? I hope that makes sense. The owner obviously must provide the lien agent information to the general contractor, and the contractor is supposed to give that to the subs as well. You can ask for it, and they're obligated to give it to you. I know a lot of times people ask for it and they don't get it, but that's what they're supposed to do. I know a lot of the larger general contractors now put it in their contract with the subs. So if you could ask for that, you get it. So one of the things we did several years ago is we partnered with Liens NC we did a webinar together, and they gave us some search engine tricks. So these still apply. If you ever have any problems, you can't find one, call me. I'll be glad to help you, see if I can help you find it. But I'll give you some tips to hopefully figure out how to get to this, right? If you are doing this and you just can't find it, if you have the entry number, that's it. That's easy, right? But think about this, you're searching for information that someone put in, and unfortunately, you have to put it in the way they put it in. So um, it doesn't, it's not searching what's close to that, how you spell that word. If it's not that word, it doesn't find it, which is a real bummer. But there are ways to get around that, right? So if you have the number, the express pass, that works. If you know the owner or contractor, you should be able to get that as well. And there are ways to do this. So this is the entry number search, which I know a lot of you have seen before. You can just put that in. I would tell you to, I don't even mess with that type, quite frankly. I go to advanced search almost every single time to look for the property address, to try that first, right? I would say this, right? Look at the information regarding the project. Is there an unusual word, maybe the street name or the general contractor? For example, if you put in DR Horton, if you typed it in, right, thinking about where the periods are or no periods or spaces, you may get a slew of stuff or you may get none. That's why I go to the advanced search and really put in distinctive words that might pop up, right? Because you're trying to narrow down what you're searching for. If you also, I think I put in here, if you know of another contractor, sub, or supplier that's on the project that has provided materials, you actually can go in and search for their name on that project. And sometimes if you can't find the actual lien agent, you can actually search it for them using a sub's name or a general contractor or a supplier and narrow it down that way, which I've done that sometimes and it's really helpful. Again, try to avoid using like street, avenue, and drive. That's not going to help you. Unfortunately, you can't use wild cards when you're entering data into this. Uh, don't use abbreviated terms or variable words. Again, you got to think about how they typed it in, right? One of the other things that I really love doing when I finally figured this out was, for example, if you want to search just for a certain a word or two or three words, put them in quotation marks. That is only limiting to those words. Like if it's an odd name street or an odd building, maybe, or an odd project name, right? You're trying to come up with something that's not going to be, obviously putting in Raleigh or Charlotte or something of that nature is not going to be very effective. But again, these are some ideas that can help you in doing the search terms, right? Notice of contract. I told you earlier, right? If there's a notice to the lien agent, the other type of notice that you need to be aware of is notice of contract and notice of subcontract. So if you're the owner or general contractor, you should, within 30 days of getting the building permit, send out, or you actually file it and post it, a notice of contract. And if the general contractor does that, then any subs that have not given a notice of subcontract are really prohibited from filing a lien on the project. That is, if they're second tier or below. First tier, you obviously know that they're there, so you don't actually have to do that. But if you're second or third tier, you actually need to give a notice of subcontract, which means you send a notice of subcontract to the general contractor and the owner and maybe anybody else in between you. So the notice of contract was designed and implemented by the AGC a number of years ago, and it really benefits the general contractors. The notice to the lien agent benefits the title insurance companies. So you just got to keep those two in separate in your mind, but at the same time, you need to know that, right? How do you know if someone has filed a notice of contract? Well, it's filed with the clerk's office. Unfortunately, it's really difficult to find. Even though now all 100 counties in North Carolina have an online data system, it is difficult to find the notice of contracts. It used to be a little bit easier because you could go to the courthouse and every county stored them differently, but you could find them. The easiest way now, quite frankly, would be either look on the database or go to the job site and ask, right? And unfortunately, the statute does not require them to be put on the bulletin board. We have found them in desk drawers. We have found them, sitting inside a locked door, a cabinet, right? Who's going to see that? No one, but that's what the law allowed them to do. But if a general contractor files and posts a notice of contract, a sub then would be obligated to send a notice of subcontract. You don't have to file it, but you have to send a notice of subcontract to say you're on the project. Um, so the service of the notice of subcontract should be within the first 30 days of providing materials or labor for best protection. Let's say, for example, you get on a project, you're providing materials or labor, and all of a sudden you realize, oh my gosh, I'm not getting paid. You could, and you haven't done your notice of subcontract. You still could go and send out your notice of subcontract. Doesn't matter if it's within 30 days. At least at that point, you started the clock rolling to get protected, right? So I would encourage you to do that if you haven't done it. So when are building permits required in North Carolina? That's sort of a summary requirement for building permits. And again, I'll just use that for you in case you have any questions about that. You're welcome to read that later. I'm not going to go through all of that in detail, but hopefully that makes some sense. So a lot of times people ask us, so what should I be doing, right, with my lien claims, right? When should I start thinking about filing a lien? Well, I would say this: if you within day 60 of not getting paid, hopefully you have an idea of what's going on, right, on the project. Hopefully you have an idea of where payment is, right, or when payment is coming. And again, depending upon what the payment terms are with your contract with your whomever you contracted with, you got to think about, right, and if is it 30 days or is it 30 days once the pay application has been submitted, 30 days from invoice, it can vary. But day 60, if you haven't been paid, we obviously need to be on the phone with someone going, hey, what's going on, right, to understand what's happening. My advice would be by day 100, you need to really, really, really be tied into, hey, something's going on. And you need to know what's going on, right? When is payment coming? If it's not coming, right? And at that point, I would encourage but because you have 120 days in North Carolina to file your lien on real property if you haven't been paid, right? And that's from the last day you've done work. So 120 days from the last day you've done work. And if you have not been paid within 100 days, you need to be making some progress towards, I would say, getting a lien filed. You don't want to wait till 115th or 19th day, right? We have a few clients who we've had to jump through hoops, and thank God it's a lot easier now with online filing. But we would really ask you not to send it to us on the 120th or 119th day. But although if you realize it, let us know. We will absolutely jump through hoops to get it done for you. But that's obviously, you don't want to rush it because you got to make sure it's right. We've got some case law that's coming up or just came up that I'll tell you about. Obviously, you don't want to rush those things. You want to make sure you get it exactly right. So what goes into a claim of lien? Well, it's a lien on real property, right? And generally, what it is, you're trying to give notice to all the world that you have a lien or claim on that real property, right? That you've done something to improve that property, either providing labor or materials or both. And so the statutes in North Carolina and also the Constitution, we're one of the few states in the United States that have lien rights as part of our state constitution, which is really, really good. But it's a lien claim on real property, and it can be on money, right? So if you're a second, third tier sub, you have a lien on the money as well by someone who is claiming to be someone who improved property and who has not been paid. You got to have the improvements on the real estate, right? And then the key is to give notice. And you want to make sure that you tell as many people as you can. There's an old adage that I remember hearing from attorneys years ago was not many people get in trouble for giving too much notice, which is a great thing to remember, right? Giving more notice generally does not hurt you. So, and that may not make any sense to you, but as an attorney, protecting your rights, that's something we want to make sure. We'll send out a lien to multiple addresses. People say, why do you send so many addresses? And it's sent certified mail typically. Is I want to make sure I'm shooting with a shotgun, a large pattern to hit as many addresses as I possibly can hit, especially if it's a subcontractor's claim of lien, because you're trying to get notice out that you haven't been paid, right? In North Carolina, right? So you got to have a person performing or furnishing labor material, and it can also be professional design, and also can be rental equipment. We actually helped the National Association of Credit Management a number of years ago to get rental equipment included in the lien statute at the time. So mostly, obviously, people stopped doing all the work by hand and was using equipment, rental equipment. So we were able to get that included. You got to have a contract. It can be verbal. Lord knows, I hope it's not, but it can be. And again, you got to have it with the owner. Somebody with the owner's got to agree to it, right? You got to know the name and address of the who you are, the lien claimant, right? The name and address of the owner. And look, I get it, right? Y'all are, unless you are dealing with the owner, unless you're a general contractor dealing with the owner, you may not know who the owner is, right? You may have an idea, but you may not know. You got to figure out who that is, and we can help you figure that out. A lot of times, if you look at the lien, the notice to the lien agent, it'll say who the owner is. We also look at the real estate records to figure out who owns the property, because that may be a different entity or a different person than the person who said, I want to make these improvements on the property. So you got to make sure you get them all right. A description of the real property. We're going to talk about this in just a minute, but most of y'all have job accounts, right? Where you separate, you're dealing with a customer, right? With subcontractor maybe, and they've got multiple projects with you, and you have each of those in a separate account, right? So you know where your materials and or labor are going. You know which job it is. You can say, I provided materials and labor to this job starting on this date, ending on this date, and this is how much I'm owed. I really encourage you to do that. I've had a conversation recently with a client that does not do that. And it is a difficult challenge for them, because if they need to lien something, they then have to go back through all of the unpaid invoices and figure out which invoice went to which project. And as also, you need to know the first and last dates, right? That is really, really key. What was your first? I just realized we left a T off the first. Sorry about that. What's the first date of improvement, and what is the last date of improvement, right? Of your providing materials. And also, what's a general description of the work you've done, and then how much is owed? So you think about this, right? If you're working for, just say it's a shopping center, right? And it's one track. That's pretty easy, probably. And it's one contract. You pretty much know where your materials and labor are within that uh, tract of land, right? Or that project. But think about this. Let's just say, for example, there's 3 homes being built, right? And your labor and or materials were going into all 3. But if you, let's say you had equipment rental or other materials or other supplies going to those, right? If you can't designate where your materials or labor went, like was it lot 1, lot 2, or lot 3, and what your first and last dates are, you're really gonna have a hard time filing your lien, right? It's gonna take a lot more work for you. So that's why we really encourage people to have project accounts. And you need to be able to figure out, okay, if you're providing, say, concrete, right? Your concrete went to, your customer said, I'm delivering it to lot 1. I'm delivering X number of yards to lot 2 and X number of yards to lot 3. That way, you know how much materials went to that project. I realize that is a perfect world, because I know we've got clients that provide a lot of materials on a project, right? And it may be like, for example, if you're in a not apartment setting, but maybe a condo setting, right? A new condo building coming up. Those condos are separate units. And if they have pre-sold any of those units, then you're going to have a different lien filing than not. So, for example, if you're providing cabinets, say, you need to know which cabinets are going into which units, so that you can then go back and say, okay, I know I provided this material and this labor to this one condo unit, right? Whatever it may be. So I hope that makes sense. I don't mean to beat a dead horse, but it really does help you going forward, right? So we've talked about job accounts, and it's easier for record keeping. And I will also say, if you're doing public work, right, for the payment bond claims, you really have to have that lined up pretty tight, right? So they dig pretty hard on those. So why are dates of improvements important? So the dates upon which improvements are made are important because the dates determine when the lien claimant's lien exists. For example, if you provided materials, just say January 1st, or labor January 1st on the project, yeah, obviously you're going forward, months and everything's fine, you're getting paid. All of a sudden you stop getting paid, and you need to file a lien where your first date of material or labor furnishing was January 1. Your lien relates back to January 1st. Even though you've been paid for some of that, it relates back to when you first started providing materials or labor, versus someone who comes on, another subcontractor that comes on maybe in June. They start June 1 and then they get to December and they go, oh my gosh, I need to file a lien. Their lien then relates back to June 1, right? Not January, but June 1. So that's one thing. And the lien on real property and funds begins the moment the first work is performed at the site, right? There are a few exceptions, which we don't have to get into today, but there are a few. So again, your lien relates back. If there are more lien claims than money, then what happens is the lien claims are paid out pro rata. Let's just say there's $100,000 that's in the pot to be paid out, but there's $300,000, $100,000 in money, $300,000 in claims. Those funds are going to be paid out pro rata on those lien claims. So your date doesn't matter as much, but it certainly could matter if you are filing a lien and you have a direct claim of lien on the property. You want a higher priority than someone else coming in later. Hope that makes sense. For example, we had a client one time before we got ahead of the bank, totally by accident, but Lord have mercy, it upset the bank terribly. And our client eventually got paid, but it was a little bit, we had to wrestle with them, but thankfully they were able to get paid on it. So again, the dates, what's the first and last dates of providing materials or labor? Again, we talked about having job accounts. Do you deliver to the site, right, or with materials, or is it picked up at the counter? And I would say, or if it's picked up at somewhere else, right, or if it's drop shipped, say, to a subs or the general contractor's yard, right, not on the job site, but to their yard. Do you know that those materials were for that particular project? So you got to think about that just a little bit, right? If a customer comes in and buys, I was just say $100,000 worth of materials, and they say it's going on X job, and then you look at X job and those materials didn't go there, you're going to have a little bit of a hard time enforcing your lien, even though you sold them with the intent, right? And I think that's covered under the statute. Eventually, you might have a difficult time with that. Hopefully, you're getting signatures at the counter. Hopefully maybe the customers are really, your customers is telling you where the materials are going, and y'all are making those great notes, even on the job, if they're doing that at the job counter, right? Try to make sure you use your actual date of delivery and not your invoice date, because those are different most of the time. Not always, but most of the time. And it really does matter. Like if the materials are being shipped by the manufacturer to the job site, what date do they get there, right? Well, that's a really key point. So I hope that makes sense. Again, I won't try to beat a dead horse on. So what are some traps, right? Again, where the materials go or supplies. If it's labor, hopefully you know that. We've got one contractor or a client who is struggling with that. And they know where the labor went, but it's hard to tell, like, on which floors they were working on sometimes, because some of the notes weren't kept up. Is the property leased, right? Is it a shopping center or a mall, right? Again, we talked about some people will tell you in North Carolina you cannot have a lien on leased property. Not true. You can. But here's an adage to keep in your mind: your lien is only as good as the lease. So, for example, a lot of times we may represent a client who provided materials or labor on a leased piece of property. Let's just say it's at the shopping center, right, that you are most familiar with. Well, you still have a lien right, but it's only for the lien. Excuse me, your lien is only as good as the lease. And more than likely, that lease, the owner is going to say to the landlord is going to say to the tenant, if you do anything that causes a lien to be filed against our property, that's a term of default under the lease. So some people say, oh, I don't want to do that because I don't want to put them in default. No, actually you want to. And I'll tell you why. If they've just spent $1.5 million on an upfit, right, and you're owed $300,000 for whatever you did for them, and if you start squeezing, right, the landlord's going to squeeze at the top, the lien claimant is going to squeeze from the bottom. Hopefully, money shoots out in the middle. So there is a lot of reasons why you would want to press that, I think. But that's just looking at it from a standpoint of they're probably not going to want to lose that lease early on in their upfit, right? So again, the other question is, do you know who owns the property? And did you send your notices out, right? This is notice of furnishing in North Carolina. We don't have that. It's notice of subcontract and notice to the lien agent. So again, that's sort of what we have for you in looking at that. Is a lawsuit required to enforce a lien claim? In North Carolina, it is. Some people say this is a friendly lawsuit between, the parties involved because of maybe the bank's not paying or the owner's not paying, whatever it may be. But if you're a first or second tier sub, you have to sue everybody above you, right? And including the general contractor and the owner in order to get paid. In North Carolina, lawsuits must be filed within 180 days of the last day of providing materials or labor. So again, if you're using a law firm to do that, I'm hoping they're keeping up with you. And if it's us, we will keep up with that date for you. If it's not, they should be keeping up with that date for you, and you should be filing, I would say file before that, 180 days, but hopefully sometimes you might be able to get it worked out prior to that, right? Between the time period of filing a lien and then the time period of having to file the lawsuit. So we talked about who's sued. You're required to sue your customer, right? If it's a sub or going in a chain, if you haven't been paid. Again, filing the lawsuit in North Carolina, all necessary parties must be included. That includes the owner, GC, any sub, or parties in the contract chain. I'll tell you what's really interesting. We have had this issue happen quite a bit, and there's a case about it that we're going to talk about in just a minute. For example, if you are say a first or second tier sub, you file a lien, you file a lawsuit to enforce that, and you get into the battle, right? And let's just say, for example, that the general contractor or let's say the second tier file the lien, first tier bonds off the lien, which means they go to the court and they post a bond so the lien is not on the real property anymore. And they say, you know what, we want to be out of the lawsuit, or the GC says we want to be out of the lawsuit because we have bonded off this lien. And this is a round circle argument among most lawyers about whether you should. Well, there's a case law that says that the bond releases the real property, not necessarily the parties, right? Depending upon who we represent is what we're going to be arguing, obviously, to protect our client the most. But that happens quite often. So again, just something to think about. We have gotten probably in the last 3 years more lawsuits and more judgments using lien claims than I think I have in 30 plus years. And it's really interesting. So the reason I even say that is a lot of times we file a lien, we eventually get the money and everybody gets happy and you go home. There are times when you get a lien, we file a lien now and we wind up getting a judgment and the lien is attached to the real property. And it again relates back to the first day of your material furnishings or labor furnishing. And we could theoretically sell the property to get you paid, right? So realize that, right? You can do that. You can foreclose on the property, the real property, in order to get paid. And so chasing the customer obviously would involve getting the judgment and attempting to collect on that, right? That's just sort of the general standards. But if you have a claim of lien, and we've gotten one on a piece of property I can think of now for, I think 3 lien claims for 3 different folks. And these are large amounts, right? Theoretically, we're going to wind up selling the property, or they got a bunch of property, but we're going to probably wind up selling the property if they won't come to the table and actually bring the money. So that does work. So we talked about a little bit, how do why do you document things? How do you do those? Do you have pictures? I've got one client who we're getting ready to go into an arbitration with them. And I asked him early on, right? There was an issue with an owner, and I said, "Do you have pictures?" He said, "Oh yeah, we got a lot of pictures." I'm like, "Do you have a lot?" He said, "Yeah, we got a lot." They had a lot. It's awesome because we're going to be able to probably shoot all the holes in the owner's claims, right? Because we have a boatload of pictures and videos. Um, Given how cheap it is to do that today, right? I would encourage you, if you're dropping materials, providing labor, doing whatever work you're doing, to take pictures along the way, right? It's easy to do that, right? Are maps and sketches useful? It is. Now that we have our phones, right? It's easier to figure out where you're dropping materials or what you're doing. Make sure you're putting in notes, right? In your whatever database y'all are using. Day timers are helpful. Obviously, not many as people are doing that with their jobs accounts necessarily, but job records or records from a job site obviously can be helpful, right? So the other thing I think about is sometimes your sales people can be great to helping you figure out where the location is, right? And then the other thing about, and just a free advice, right? Your emails, right? Don't be evil, don't be ugly. Think about the standard of, would you be okay if your company, if your email showed up on the company's website, right? Or if the owner was reading your emails, or number two, if your mama had to read it, right? Would she be proud of you? So just think about that sometimes, right? I know most of y'all are really good about not lashing out. It's not personal, right? So here's some recent cases. This is one that came back a while back, and it really has to do with the reason I was bringing it up is it has to do with corporate names, right? I see a ton of contracts in our business, and it's really interesting. Sometimes they are dotted and crossed to the T. It's awesome, and other times it's just the names of the parties are not complete, or the names of the parties are it's like an abbreviation. I would really encourage you to make sure that you use the right names of the company, right? Try to be really careful about making sure that it is the correct name of the company and not maybe a DBA for them. Um, and then this contract also, or this issue, this case also dealt with if a contract is under seal, and then allowing testimony to clarify those contract terms. This was one of those where we were ahead of the bank, and it was awesome to be ahead of the bank, but the bank did not want to let it go. But thankfully, eventually the court said they had to. This is a case that came up in May of 2025. There was a claim of lien. It did not include on the claim of lien the last date of performance. Again, we've talked about why that's important, right? And I don't know why I don't know who filed it. I don't know if it was a law firm or probably it was a law firm. I don't know that. But for some reason, they did not include a last date of performance. Well, the court said that was defective, right? You can't have that, and they threw the case out. So you don't want to mess up your lien claims, right? It really is key. Let me also say this to you, just in case you need to know this, in case you're doing your own liens. If you are, I would tell you to be really, really careful and make sure you are dotting the I's and crossing the T's. You cannot amend a claim of lien in North Carolina. So, for example, let's just say that in this Fine Line Homes case, they realized, oops, we didn't have the last date. Let's just go ahead and amend our lien because we already filed it and file a new one. Well, you can't do that. In North Carolina, you can cancel that lien and then file a new one if you're within your 120 days. But if you're outside of the 120 days, you cannot amend your lien, or you can't file a new one, right? You're stuck with it. So you got to make sure it's right. And let me also say this: sometimes some people will be working on a project, and for some reason, whatever, the project stops, right? Well, whatever your last date is, that's when your last date of performance is. Even though you're supposed to go back out, you need to count the day that you were your last out there. But what happens, say, for example, that you are on a project and for whatever reason you don't file a lien claim, right? You get talked out of it, you forget about it, you just say, you know what, it's not worth it. If you are a first, second, or third tier sub in that chain, you could be a year out, right? As long as there's money still in the chain, you could send a notice of claim of lien on funds and capture your right to get paid through the funds. There is no time frame on that. So if you're out, like you miss it by 60 or 90 days, whatever, and you go, what if there's any money, and you find out there's still money left, you could still do a lien on funds and capture your lien on the money itself. So if that makes sense, call me and I'll talk to you about it. So this is a case that came out right at the end of 24, where a partial lien waiver was signed, and the court said that did not extinguish a subcontractor's subrogation rights. So, for example, a sub filed or signed a partial lien, not a full, but a partial lien waiver, and the court said just because they signed a partial, there's still lien rights available, so that other subcontractors below them could have rights to those subrogation claims, those subrogation rights. So it says a partial lien waiver may limit the amount of a sub's claim to the amount remaining on the contract, right? So again, if the subcontractor did a partial lien waiver, say for $100,000 payment, but they're still owed $300,000, a lower tier sub could use their lien rights by subrogation of the sub ahead of them to do a lien on funds and capture that the partial lien waivers didn't extinguish all lien rights. So I hope that makes sense to you. If you have any questions, let us know. We've talked a lot about a whole bunch of different stuff today. We really hope that this is helpful to you. If you have questions, please let us know. And we hope that you will be on our next webinar, which is in April, on April 16th. Thank you all so much for attending.